Hello, everyone. Thank you so much for joining us today. I'm Samar Shams. I'm a partner in the immigration team at Spencer West. And I'm joined today by my colleague Talita. Talita, do you want to say hi?
Hi, I'm Talita Degwal, an associate partner also in the Immigration and Global Mobility team at Spencer West.
So we have a very exciting and chock full webinar to present to you today. It's all about the new immigration rules and the future immigration system. So without further ado, we'll get started. Please do feel free to ask any questions you might have in the chat. We'll get to them as soon as we can. And we'd love to know what your questions are as we go along. So please do put them in the chat. So today we're going to talk about European Economic Area nationals, the skilled worker route, the intra-company transfer route, new English language and maintenance requirements, the student route, visitors, the British national overseas route for residents of Hong Kong, and a few other routes and a special exception relating to the pandemic and absences for settlement. So let's get started. European Economic Area nationals. So, as many of you will be well aware, we're in the transition period at the moment. That's the post-Brexit transition period, and this is coming to an end at 11 p.m. on the 31st of December. Now, a lot of people have the conception that all the immigration rules are changing from the beginning of January, and that's not really the case. It's not that there will be many changes to the immigration rules. It's that the immigration rules will apply to European Economic Area or EEA nationals for the first time. So they won't benefit from the freedom of movement rights that they did under EEA legislation and that have continued during the transition period. Now, we are discussing changes to the rules today. And some of them are taking effect on the 1st of December. There are some taking effect 1st of January and some later next year. But really, most of the rules that form the future immigration system are either already in effect or will already be in effect by the time we get to the 1st of January. So again, it's not that all the rules are changing, it's that they will apply to EEA nationals for the first time. And in terms of the existing immigration rules, including the rules that are changing and the changes we're discussing today, it's important to keep in mind that EEA nationals who are already within the UK and make applications under those rules before the end of the transition period, those applications will be rejected as invalid. Those EEA nationals who are outside the UK and make applications under the rules, other than the EU settlement scheme that we'll discuss in a moment, those visas will not take effect before 1st of January 2021 at the earliest. So I hope that's clear. So what should EEA nationals and their family members who are already in the UK do? Talita?
Thank you. So EA nationals already in the UK, if they haven't already done so, should be making plans to make an application under the current EU settlement scheme for permission to remain in the UK. There's two types of applications which can be made. The first one is for pre-settled status, and this is for individuals that have lived in the UK for less than 5 years. And the second application is for settled status, and this is for individuals that have lived in the UK for at least 5 years, and they would apply for settled status. Sam has already mentioned the key dates, so EU nationals should be in the UK by 11 p.m. on the 31st of December 2020, and they do then have until the 30th of June 2021 in order to make an application under the EU settlement scheme. But we do advise that these applications should be made as soon as possible rather than waiting until the deadline.
Yeah, that's right. And that's basically because those who are here before the end of the transition period, and those EA nationals who arrive after the end of the transition period um, would both just have EEA national passports to show. If those who are eligible for the EU settlement scheme haven't applied yet. So if you don't have status, then you'll just have the same documentation as somebody who arrived after the transition period. And although the Home Office has said they don't expect employers in the UK to differentiate between those two groups of people until the 31st of June 2021, you don't really want to be in the situation where you have an employee that you thought had the right to work and didn't. I see there's a question in the chat from Sana. Hi, Sana. Thanks for your question. This question is really very specific to your situation, Sana. So I think it would be best if you got in touch with us directly to explore your possibilities in London on the basis of your master's in human resources. So I'm going to talk a bit about family members. Those family members who are with their EEA national, with an EEA national in the UK now can apply to the EU settlement scheme. Those who are arriving afterwards might also be able to apply. It's crucial, though, that the relationship on which their application is based exists at the end of the transition period. So what does that mean? Well, for example, there might be a French national living in the UK now, but their non-EEA spouse is not in the UK. They're living elsewhere at the moment. Because they're already married by the end of the transition period, the spouse will be able to join that French national who was here before the end of the transition period in the UK going forward. And the requirements will be very similar to what they are now under the EU settlement scheme for that applicant. Now, what are being referred to as new family members, so let's say if the French national in the UK hasn't yet met their lovely future spouse, those family members would have to come in under the other immigration rules that apply to British nationals trying to bring family members in, which are significantly trickier, actually. So the pre-existence of the relationship is key in terms of family members joining later. So if there aren't any other questions, we'll just move on and discuss the skilled worker route. And we're really going to focus on this today because the skilled worker route is the route that has had the most significant changes in the most recent rules changes, which were published on the 22nd of October. And so we are going to go into these in quite a bit of detail, and I hope that's helpful to people. So, Talita, do you want to give us the basics on this route?
Yeah, so the new skilled worker route is essentially replacing the current Tier 2 general route. A UK employer will still require a sponsor license if they already don't have one in order to sponsor workers to work for them in the UK in a specific eligible job. The route still requires migrants to have to demonstrate English language ability, and workers can still bring dependent partners and children with them to the UK. And this route will still lead to settlement like it does with the current Tier 2 general route.
Okay.
Okay, so one of the major exciting changes with this skilled worker route is that the skill level is actually being dropped. So under the Tier 2 general route currently, the level, it has to be a highly skilled job at the regulated qualification framework level 6 or above. However, this is now being dropped to level 3 or above, which is essentially an A level or equivalent level role, it doesn't mean that the worker needs to hold any formal type of qualification at this level. Just it's more important of what type of level the job is. So as the skill level is now being dropped, this will now include much more medium skill roles. It will still continue to include the higher skilled occupations as it currently does, but has now obviously added other industries and roles which were previously ineligible for sponsorship. We have listed some of the affected industries and roles on the slide that are now eligible for sponsorship. This is not an extensive list, and there are many more industries and roles which have been added. So we've got building construction, manufacturing, engineers, retail, property and housing, tech, business support, mechanics, and restaurants. So none of these industries or roles were previously eligible for sponsorship, but from the 1st of December, businesses will be able to sponsor roles, for example, in the ones listed on this slide.
Yeah, I think this is a really exciting change that, given the volatility of the year and the turbulence this year, people have not properly recognized. I don't think people recognize the significance of this change. It's really very exciting that so many roles that have never been eligible for sponsorship will now be eligible. Yeah, today's no exception to that level of volatility, given the US election hanging in the balance and new lockdown restrictions coming in the UK tonight. But if you're in one of these roles, or you're curious, if you're in a business that deals with one of these roles, or you're curious about other roles that might not be listed here being affected, do get in touch, because it really is a very exciting change. And Sana, this might be a visa option for you, the skilled worker route. If an employer in the UK would sponsor you to work in these roles, or roles at higher skill levels, that could be an option. And we have a question from Mahesh Jain asking, how do staffing businesses play a role in the skilled worker route? Well, there is still a restriction on agency workers, so the sponsor does still have to have full responsibility for the work of the migrant and their outputs. So a kind of agency that supplies workers very simply to other organizations is not eligible under the skilled worker route. The skilled worker route really should just be seen as a modification of the existing Tier 2 general visa route. So we'll discuss what's changed here, but anything that we don't discuss today, I think it's safe to assume hasn't changed because it is based on the Tier 2 general route. So we have another question from Sanjay about whether certificates of sponsorship are still required. They are. But we'll discuss some changes to how that works in a minute. Salaries we'll discuss in a minute. Sanjay has a question about salaries. And they are, and we'll also address whether the worker is tied to the employer. Thanks for your questions. It's very exciting. Okay, Talita?
Yeah, so the Home Office have also made another change where they'll be suspending the current annual limit, whereby there won't be a limit on how many restricted certificate of sponsorships the Home Office will issue to an employer. This is also great and welcome changed again, so there won't be any restrictions on how many certificates an employer can assign to potential workers. Interestingly, the Home Office have used the word suspension rather than abolish. So it does make us think that this annual limit could potentially come back into force in the future, but the Home Office haven't made any comments on this yet. So it's probably one to look out for. The other exciting and substantial change is that the Home Office are abolishing the resident labour market test. So currently under the Tier 2 general route, unless an exception applies, the employer would need to advertise the job to the local labour market force to see if they can find a suitable settled worker to fit the vacant role. And only then, once they can't find one and have satisfied this test, can they then offer the job to a migrant. This is now being removed, so there won't be any requirement for an employer to have to advertise to the labour market for at least 28 days. That's is going to be gone. And this is also great because it can reduce the processing times for onboarding a migrant worker as well. So this can potentially reduce the time to by at least a month, because you wouldn't need to advertise the vacancy for at least 28 months, then go through all the applicants that have applied, do interviewing and so forth. So great change. Employers will not need to advertise to the local labour market first and can go on and offer the job to a migrant worker if they have established and identified one.
Agreed. That's a really great change. It also just helps with the overall project management of onboarding a migrant worker, because it removes a lot of the timing requirements that are so tricky in those situations. Not to, it's great not to have to advertise for 28 days going forward. Another change that will have sponsors cheering in the streets is the abolishment of the cooling off policy. So cooling off is basically a policy whereby if a tier 2 general migrant leaves the UK, leaves their job in the UK, their sponsored job, then they're not eligible to return under tier 2 for at least a year from the time they left the UK. Similarly, if a sponsored migrant is in the UK and switches to another visa route, and so again, they're no longer sponsored, they won't be eligible for tier 2 again for 12 months. So that policy is being abolished, and it's great because really restricted changes of employment and made all of those situations trickier. So that's a really welcome change. They're also removing the £38,500 salary threshold for settlement, but going forward, roles are still going to, sponsored workers are still going to have to be paid at least the higher of $25,600 or the going rate. And there are some exceptions to that if the job's on the shortage occupation list, and some other exceptions for certain roles, but that's basically the new salary threshold requirement for settlement. So we have some more questions.
Yeah.
Mehdi's asking if an overskilled worker can incorporate a company, an overseas skilled worker can incorporate a company in the UK and apply under the skilled worker scheme for themselves. No, they cannot do. Hasna, hi Hasna, is asking regarding adverts, if we have a role with a flexible location, do we still specify London or the UK? That question makes sense. So what Hasna is referring to is a requirement in the current advertising guidelines where you have to list the location of the role. So for the skilled worker route, you're not going to have to advertise at all anymore. So I don't know if that kind of negates the need to answer the question, but if not, I would put London in the ad and put as much information about the location in the ad. If it's flexible, etc., I would just state that in the ad. Talita, do you want to take Sanjay's next question? Can you see it?
Yeah, he's asked, can vendors who supply labour to industry also issue COS? I think this is more about what you mentioned previously about agency workers. So if you're supplying workers to other businesses, fortunately you can't do that under the current route, and you wouldn't be able to do it under the skilled worker route. It would have to be the sponsor who's hiring the migrant to work for them, their business, who would be the person issuing the COS. So I hope that answers your question.
And then Sana says, I'm presently living in Pakistan. How can I approach an employer in the UK? for a skilled worker route job. Basically what I would do, Sana, is look at the vacancies listed that are relevant for you, and then look at the list of registered sponsors and compare the employers who are showing relevant vacancies for you. Check if they're on the list of sponsors. Those who already have a sponsor license are much more likely to be amenable to sponsoring you. Then we have a question from Mahesh about rights of changing employment in the UK. Yes, those restrictions are largely the same in terms of changes of employment. Husna and Sanjay, you're both most welcome. Thank you all for your questions. We'll move on now and discuss in more detail the new salary requirements. So this is, if I had to designate one part of the new rules as the real meat of the new rules, this is it. And this is also the basis on which the government describes the new immigration system as a points-based system. This is, in fact, the only true points calculation in the whole system that will be in effect from 1st of January. These changes are coming into effect on 1st of December. So basically, rather than the £30,000 minimum salary threshold for the category of Tier 2 general worker, the skilled worker route is going to have an absolute minimum salary of $20,480. Now, for most roles, the category threshold will likely be higher than that. I'll explain in a minute. You would earn, if you're meeting the $20,480 salary threshold, you could then earn the necessary points to make up the difference to meet the required points through PhD, the job being on the shortage occupation list, or being a new entrant. Let me explain. So in the rules and in what will, and in the guidance that's likely to be published when these rules come into effect on 1st of December, there's quite a complicated way of explaining how to gain salary points, but I have a simpler way of explaining it. Basically, consider these two tables, okay? And what you have to do is you have to satisfy the conditions in at least one of the rows in the first table, even if you get 0 points, okay? So look at the first table. You'll see a salary threshold, something described as the going rate, and the number of points you would get, okay? Now, the going rate is listed for each job in the immigration rules, okay? So there's a list of occupations in the immigration rules. It purports to cover all the possible jobs one might have, and then alongside the description of the role and the titles, there's a list of the going rate. Now, the going rate listed there is based on the 25th percentile of salaries for that occupation in the UK, okay? That's what it's based on. That's what going rate means. Now, if the salary is at least $20,480, looking at the first row here, and at least 80% of the going rate for the profession, then you satisfy one of the rows in this first table, but you get 0 points, okay? So that's the minimum you can do. You can, the role is eligible where the salary is 70% of the going rate if the applicant is considered a new entrant to the labor market. And that means anybody who's under 26 or is switching from a student visa or is applying to certain categories, but basically anyone under 26 or switching from a student visa would be eligible. Okay, so you satisfy one of the rows in that table, but you get 0 points. So you're going to have to then look at the second table to make up the points. You need a combination of, you need 20 points. You need to gain 20 points from both of these tables together, for, you know, satisfying what you can from the first, and then the second, you need 20 points to satisfy the salary requirement, okay? So we got 0 points in the first table in that instance. Let's look at the second table. Is does the applicant have a PhD that's relevant to the job? Okay, and it's going to be up to the sponsor to verify this and confirm this to the Home Office. If so, they get 10 points. Not enough, because you're only allowed to earn points from one row in the second table. Okay, you can't combine. So if we only satisfied the first table, the first row in the first table, and we only satisfy the first row in the second table, the person's not going to be eligible. The role's not eligible because there aren't enough points gained. But they could gain enough points if they had a PhD in a STEM subject, that's relevant to the job, or the job is listed as a shortage occupation. That list is in the rules. Or the applicant is a new entrant to the labor market, as I discussed, okay? So in those cases, the minimum salary for the category is just 20,480 if you get 20 points in the second table, okay? And then you can see the category salary threshold goes up in the other rows in the first table. If you are earning 23,040 pounds or more and at least 90% of the going rate for your occupation, you get 10 points. And then you could use the PhD in a subject relevant to the job to gain the other necessary 10 points. So that's what you're looking at. And you'll see that the third row in the first table lists salary of at least 25,600 and at least the going rate for the profession. You get 20 points, okay? And that's why you'll see, it's often described that the minimum salary threshold for skilled workers, or what is currently Tier 2 General, what will be skilled workers, is dropping to 25,600. Because if you make at least that much and you're paying the going rate, then you earn all the 20 points you need from that third row in the first table, and you don't need to look at the second table. So I hope that was clear. Let me know if you do have questions. Sana's asking, is Tier 2 the same as the skilled worker route? If yes, then why the change of name? Are there any differences? So Sana, this whole webinar is about the differences. The skilled worker route is a modification of Tier 2 General, a subcategory of Tier 2. And the change of name, the Home Office described it as getting rid of, modernizing the terminology to get rid of the tiers, description of tiers. Okay, any questions about these salary calculations? Because this is what people need to be doing now, what businesses need to be doing now to prepare. Look at the roles you want to recruit for, assess how the salary requirements are met to ensure that you're going to be able to get the talent that you need. If you have any specific questions about particular roles, get in touch, but you're welcome to ask more general questions now. Talita, do you want to tell us a bit more about what counts?
Yeah, so obviously Sam has just been through the salary thresholds which need to be met. And the Home Office have confirmed that the salary will only be taken, the only thing that will be taken into account is the guaranteed base gross pay. And this is a change because under the Tier 2 General route, you can currently include allowances and benefits such as guaranteed bonuses, guaranteed one-off payments, and so forth. However, the Home Office have said that in order to meet the salary thresholds, it will just be the basic gross pay that will be taken into consideration. It doesn't stop the sponsor, obviously, from giving these additional benefits and pays to the employee if they wanted to. It just means they wouldn't be allowed to be used to meet the salary threshold for the application.
Okay.
So there are going to be transitional arrangements in place, and this is for people that are already in the UK as Tier 2 General migrants and are either applying to extend their visa in the UK or apply for settlement. So the first transitional arrangement is for the employer to include allowances as part of the salary. And in order to do so, the following criteria would need to be met if an allowance was going to be included towards the salary threshold. The second transitional arrangement is for the requirement to meet the salary threshold, and the Home Office have said that the salary should be at least the 20,800 or the going rate. And the following criteria would also need to be met if you wanted to rely on this transitional arrangement.
Okay, so we have a question from Ian. Hi, Ian. On what basis can we reject a switch to a skilled worker application? And how do we ensure it's fair if we do it for some and not others? So actually, from an immigration perspective, a sponsor is under no obligation to support a switch to a skilled worker, to the skilled worker route. Let's say you know, the worker comes to the end of their tier 2, the duration of their tier 2 general visa. There's no obligation in terms of immigration requirements to continue to sponsor them. What is significant is employment obligations, obligations under employment law. Unfortunately, I'm a very humble immigration lawyer and I can't speak to that. But I could definitely put you in touch with some of our colleagues who practice employment law and are well-versed in discrimination, unfair dismissal, etc., which might be some of the issues cropping up here and could answer that for you. But yeah, in terms of sponsorship responsibilities and other immigration requirements, the sponsor is under no obligation to facilitate a switch or to continue sponsorship. You're most welcome. So we have another question from Sanjay. Can employees on a tier 2 intracompany transfer apply for a skilled worker route if they get a sponsor without any break? We are, I think, going to address that for you, Sanjay. We're going to talk about intracompany transfers in a few moments. If we don't answer this question, please let us know, but I think we will. All right.
Okay. So the next requirement, which is still the same as tier 2 general, just slight changes, is the maintenance requirement. So the main applicant will have to hold at least £1,270 in order to meet this maintenance requirement and also evidence these funds. Alternatively, the sponsor can certify their maintenance on the certificate of sponsorship, which is assigned to the individual. And in this case, means that the applicant wouldn't need to provide any additional documents to show that they hold the funds if the sponsor is certifying their maintenance. There also is a change in how dependents need to evidence they meet the maintenance requirements. So there's now 3 different levels of funds that need to be held. So the first one is for the dependent partner, £285. First child, £315, and then any other child is £200. And all the funds must be held for at least 28 days. There also is a new exception which has been added to the rules and very welcomed, is if the migrant has already met the maintenance requirement under the current route that they're on and have lived in the UK for at least 12 months or more, they don't then need to meet the maintenance requirement again, which is great because currently, regardless of the route you're applying under, every time you make an application, you do need to satisfy the maintenance requirement. So obviously, if the Home Office have said, if you previously met this on the current route you're on and you've lived in the UK for the required period of time, you don't need to evidence maintenance again.
Okay, so we have had a couple of questions on intracompany transfers. Let's discuss the route now. Do let us know if we haven't answered your questions by the end of this section. So I'll just run through the basics of this route. So what's going to be called the intracompany transfer route replaces tier 2 intracompany transfer. And as the name implies, this route is for employees who are transferring from linked overseas businesses or other organizations. So overseas entities that are linked to the UK sponsoring entity, okay? Now, generally, there is a requirement under the intercompany transfer route that the employee have 12 months of service as an employee with the overseas entity. But there's an exemption for what are deemed high earners. And that's anyone earning £73,900 or more in salary a year. There's no 12-month service requirement for those individuals. English language is not a requirement of this route, and dependent partners and children can join. So this sounds lush. Why wouldn't everybody use this route? Well, intracompany transfer migrants are not eligible for settlement, and there are no changes to the minimum salary threshold or the skill level. So the current salary threshold of $41,500 for this category is maintained in the new rules, and the higher skill level regulation qualification framework level 6, which is equivalent to graduate skill level, is also maintained. So unlike the new skilled worker rules, the salary and skill levels for intracompany transfer are not changing.
Okay, so there's going to be some changes to the calling off period and the maximum time allowed under this route. So currently under the Tier 2 ICT route, if a migrant was to leave the ICT route, they will be caught by the calling off period, which would then essentially mean that they would have to wait at least 12 months before re-entering on this route. So the slight change with this is that the Home Office have said that the maximum time people can stay in this route is no more than 5 years in any 6-year period. And if the migrant is in a high earner ICT and earning at least 73,900 or above, they can remain in the route for no more than 9 years in any 10-year period. So this is also a great change because it allows much more flexibility to move in and out the route depending on the business needs and so forth, and not being caught by the 12-month calling off period.
So just to be clear, under the new rules, intracompany transfer migrants will be able to switch to the skilled worker route. There are no particular requirements that apply to intracompany transfer migrants in that situation. They have to satisfy the requirements of the skilled worker route when they apply in order to switch, which means that they can come to the UK having been transferred with one sponsor and then switch sponsors within the UK. So I hope that answers some of the ICT questions. There's another question about those who have completed 5 years on an ICT, can they now switch to a skilled worker visa? I think the answer to that would be yes. I would maybe get in touch for advice on your particular situation if you plan to make that application, but I don't see why not. What do you think, Talita?
Yeah, definitely. I mean, you wouldn't even have to really wait the 5 years if, you know, during the period of a year or two, whatever, they did find sponsorship in the UK through an employer, they could potentially switch, which is what we were going to come on to on our next slide. So with this route now, you can obviously switch into it if you wanted to. And the main change is that you can actually switch out of this route. So like a lot of people are asking, can you then switch into the skilled worker route? Well, yes, you can. You would need to find a UK employer that has a sponsor license and is able to offer you a role to work in the UK, and then you could essentially make that in-country switch application. You could also switch into some of the other routes mentioned on the slide as well. One of the main advantages for doing this is that the majority of the routes mentioned on this slide lead to settlement. So, for example, if you did switch into the skilled worker route, you could, after 5 years, apply for settlement in the UK. But it should be noted that any time spent as an ICT migrant under this route would not count towards settlement. So you would need to, the clock would basically start from when you switched into the skilled worker route, for example.
Yeah, that's a really good point, and it's a good reason to go ahead and apply to the skilled worker route now if you're eligible, because the time you won't start accruing time towards settlement until you do. And the skilled worker route, the global talent route, the innovator route, all lead to settlement in the UK. Startup and student do not. Just to clarify that. Sanjay has asked whether the cooling off policy will catch out applicants who are switching from tier 2 intercompany transfer to the skilled worker route. Well, it won't, because it's abolished for the skilled worker route. So there's, previously there was a catch-all tier 2 cooling off period, but now they've separated skilled worker and intercompany transfer, and they have different cooling off policies. And so, yeah, there's no cooling off prohibition there in that switching situation. Candice asks, what's the best way to learn about these changes without reading 500 pages of policies? Well, hello, Candice, and thank you for that question. I would say follow Talita and I on LinkedIn, check in on the Spencer West website, because we really do put a lot of time and effort into continually updating our contacts. We have a newsletter as well, which everybody is very welcome to sign up for. Just get in touch if you'd like to be added to the list. We do try to keep people updated as best we can. So for example, Talisa and I have just worked on updating the COVID policy article on the Spencer West website. So check that out.
I think I would just add to that as well, that this webinar is really based around those new rules that have been issued. So the 500 plus pages, we have tried to obviously condense that within this webinar. So hopefully you find it helpful.
And we'll be circulating a recording. I'm just conscious that we're now quickly running out of time, and we still have a lot to get through. So we are going to move on, but we will answer the remaining questions about skilled workers at the end, if there's time, or we'll get back to you after the webinar if not. We just want to make sure to tell you about some of the other changes in the rules. So sorry about that. And do keep asking, it's just that we might not get to them till the end.
Yeah. So then the maintenance requirement, which is essentially the same requirement that needs to be met under the skilled worker route, which you've just been under and we've just spoken about. So we've just put the slide here again for your information. And also under the ICT route, the new exemption does apply. So if you previously met this maintenance requirement and you've lived in the UK for 12 months or more, you wouldn't need to then meet the requirement again.
Okay, so there are also some cross-cutting changes to English language and maintenance requirements, which I'll just set out very quickly. So when I say cross-cutting, I just mean that these affect various visa types. So for both the English language and the maintenance requirements I'm going to discuss now, all of these visa types that are listed here are affected. So skilled worker, intracompany transfer, innovator and startup, global talent, the new British national overseas visa, and some other routes. And then beyond those, some of the English language changes apply to some routes, and some of the maintenance requirements apply to some routes. So if you're curious as to whether it applies to routes not listed here, please do just get in touch. So the main changes in English language are that applicants will only need to demonstrate English language ability once, but keep in mind that at different stages in a migrant's journey, they are required to demonstrate differing levels of English language ability. So if that level goes up, they might need to still demonstrate their English language ability again before, say, qualifying for settlement, for example, depending on the route. Applicants can now rely on GCSE or A-level or Scottish Highers if they were, if they studied at those levels in the UK. And a higher education provider is able to confirm that they've assessed a degree level course applicant. They'll also have to confirm how they did so. But that's a welcome change for the student route. So in terms of maintenance, as we've discussed in relation to a couple of the specific routes we've looked at, there's an exception for having to demonstrate the ability to maintain and accommodate oneself if you've already been in the UK for a year. And the required time frame for having held the requisite level of funds is being made uniform at 28 days, which is great because for some categories at the moment, you have to show 3 months worth of bank statements showing the requisite level to be eligible. And sometimes people end up just, putting money in an account and waiting 3 months just to meet the exact requirements of the rule. So that's a welcome change. And again, very small point, but makes a huge difference to applicants. Electronic bank statements will be accepted. So I can't tell you how many times I've told an applicant to go and have bank statements stamped on every page by the bank, or to get an authenticating letter for their hard copy bank statements from the bank. And banks just balk at that, or they want to charge £20 a page to stamp each page. So I'm so pleased about this change. It shows what an immigration nerd I am, but yeah, really pleased electronic bank statements are being accepted. Talita, do you want to talk about the student route?
Yeah, so the student route. So a majority of the rules for this route have already come into force on the 5th of October. However, the remaining changes that were issued in the Statement of Changes on the 22nd of October will come into force on the 1st of December. So EU nationals obviously would be able to apply under this route, but cannot do so before the 1st of January. If they're in the UK and they apply under this route before this date, the application will be invalid. If, however, they do apply from overseas before this date, then providing the application is successful, the valid date on the visa will be from the 1st of January. English language still needs to be met, and as someone said, some universities can assess this themselves. And also the other change here is this only needs to be met once as well. The maintenance requirement's still there. The Home Office have actually increased the amount of funds that needs to be held. So we've listed here, obviously depending on where the student's studying. So if they're in London, they need to hold the requisite amount of funds listed on the slide. And if they're studying outside of London, that will be the same. The funds need to be held for up to, need to cover a 9-month period, and these need to be held and shown in addition to the fees. The maintenance requirement as well has the new exception under the student route. So obviously if you previously met this requirement and lived in the UK for a year or more, you don't then need to show these level of funds. So one of the other changes is that the Home Office have removed the 8-year limit on how long students can study at a postgraduate level course. And just like the ICT route, you can now switch into this route or switch from this route. And skilled worker is listed there, so a student can potentially find a UK employer that's willing to sponsor them and switch into that route, and which would then go on to lead to settlement. Just like the ICT route, any time spent in the UK as a student would not count towards settlement. Visitors. So there have been a few changes with visitors. So obviously from the 1st of January, EU nationals will be listed on the non-visa nationals list, which essentially means that any EU nationals traveling to the UK from the 1st of January will not be required to make an entry clearance application prior to travel, and instead can travel to the UK and essentially make their application at port to the immigration officer on the day. The other change is that visitors can now study in the UK for up to 6 months, as long as it's at a an approved institution. And visitors can also volunteer for no more than 30 days, as long as it's with a UK registered charity. but visitors could previously do this, but they had to show that it was incidental to their visit. So the Home Office has now removed that and actually said that visitors can volunteer as long as it's with an approved UK registered charity.
Which is great, because the requirement that the volunteering be incidental was quite a gray area and a bit confusing. I just want to make one comment about studying in the UK for up to 6 months under the visitor rules before moving on, and that is that these, study programs under the visitor route, undertaken under the visitor route, cannot include work placements. So that's something to keep in mind. If there's a work placement that's part of the course of study, then the applicant is going to have to come under the student route. Of course, if the study is for more than 6 months as well, then that would fall under the student route, not the visitor route. So I'm going to tell you a bit about the British National Overseas Visa, and I won't dwell on it too long. We did have a full webinar on this new route a few weeks ago, so feel free to get in touch if you want more information. But there were some further details published in the latest rules changes, which were published on the 22nd of October. So I am going to quickly run through this route now. So basically, the British National Overseas Visa route is for residents in Hong Kong who were there when the British handed Hong Kong back to China in July, I think it was, of 1997. Okay. Then Britain gave those residents this special status, British National Overseas status, okay? And now what the UK is doing is they're offering British National Overseas status holders a route to come and live and work in the UK and to eventually settle in the UK. That's not part of what they currently enjoy, the rights British National Overseas status holders currently enjoy. Now, the latest round of rules changes confirmed that this route will be open from the 31st of January. So previously we thought it might be a bit earlier, but it's going to be the 31st. And people can apply from outside the UK, and they can also switch from within the UK. It's important to keep in mind that this route is for people with British National Overseas status in Hong Kong. They don't necessarily have to have a passport. The Home Office has said that they should be able to find people's records as status holders. So just because you never applied for your BNO passport doesn't mean that you're not eligible. And again, the real attraction of this route is that it allows for settlement in the UK. Now, there's also a separate type of visa for people who were born after 97 and so don't hold BNO status themselves, but they're a member of the household of a BNO status holder. So some of the eligibility requirements are listed here. You have to normally live in the UK or Hong Kong. You have to meet maintenance and accommodation requirements. You have to show commitment to learn English. I think we're going to have to see what the guidance says about that. It's a bit unclear at the moment. English language requirements will apply at the settlement stage. You'll need a certificate confirming you're free from TB if you're applying from certain countries. And there are, the Home Office will look into your criminal record. Immediate family members can join. So you can apply for a 2.5-year long visa, or you can apply for 5 years at one go. If you get 2.5 years initially, then you can apply to extend. We don't know yet what the visa fees are going to be. So there might be it might be cheaper to apply for all 5 years at once, but we're not sure yet. And again, you have work and study rights and ultimately can settle in the UK on this visa type. I see we got a question from Sanjay about students. Again, we'll just get to the end of the presentation now, and then we'll take the remaining questions. Talita, do you want to talk about other routes to settlement? Sorry, other routes and a settlement exception? Excuse me.
Okay, so we've obviously been through the routes that have the substantial changes. The Home Office has confirmed the routes listed on this slide do not have any substantial policy changes and will continue as they are. There are some minor changes to the youth mobility and global talent route, but nothing substantial. And then we get onto the continuous residence and the exception, pandemic exception for settlement. So the continuous residence is when you're essentially applying for settlement. So for example, if you're applying under the skilled worker route, and in order to apply for settlement, you would need to prove that you have held leave under that category for at least 5 years. And during those 5 years, showing your absences. And the rule on absences is that you have not been at the UK for more than 180 days in any 12-month period during that 5-year period. There are some exceptions to the absences and what's counted and what's not. And the Home Office have updated the rules to say that if a visa holder has been outside the UK due to the global pandemic, those absences wouldn't count towards the 180-day limit, which is great because, you know, there's been quite a few people stuck abroad or probably still are stuck abroad and obviously worried about how their application is going to be affected for settlement. So the Home Office have confirmed that any absences due to the global pandemic will not be counted towards the 180-day limit.
Yeah, that's great. So that comes to the end of our prepared materials for you. You'll see here our LinkedIn URLs. Please do connect with us there. We have also written an article summarizing these changes, which you can find on the Spencer West website, and we'll be updating that and publishing further articles as information is made available. So now let's go back and look at some of the questions we didn't get to. Thank you so much. We love your questions. So AP asks, are applications for the skilled worker route underway and are forms available now? So the route's coming into effect on 1st of December. So no, applications are not underway. For certificates of sponsorship that are assigned before that date and where the visa application will be made after that date, on or after that date, then there are specific things that a sponsor needs to do when assigning the cause and in relation to the cause, the certificate of sponsorship. So do get in touch if you're in those circumstances. But generally, in answer to your question, the route goes live on the 1st of December. Talita, do you want to answer Mohammed's question?
Yeah, so he's asked, is there a cooling off period for an ICT worker returns to their home country and reapplies for entry clearance in the skilled worker route? No, so we did mention that there are slight changes to this. So if they're returned and then wanting to come back in under a different immigration route, such as the skilled worker route, they would not be caught by the cooling off period.
Then Sanjay asks, how many years would students need to be studying continuously for settlement? So there's no, as we said, there's no route to settlement in particular through the student route. There is a rule based on long residence in the UK, whereby if you have been lawfully resident in the UK for 10 years, then you are eligible to apply for settlement. So basically the removal of limits on student extensions means that students might be eligible for this rule going forward. But this is a point I would keep my eye on. I think that this point in the rules is in flux, and I wouldn't rely on being able to do that. I would say, if possible, switch into a route that actually leads to settlement rather than trying to get to 10 years on a student visa. Did you have anything to add to that, Talisa, or what do you think?
Yeah, no, I agree with what you said. Definitely, if you can try and obtain sponsorship in the UK and switch into the settle skilled worker route, that would probably be your most advantage, really, in for a route to leading to settlement. So Mahesh asked, can this presentation be made available on mail or a website? Yes, I think we'll be circulating a link to the recorded session, and it will also be made available on the Spencer West website as well as our YouTube channel. Also, Sanjay has asked, any changes to post-study work visa?
I'll answer that.
Yeah.
So the post-study work visa is a visa that was a visa route that was terminated a few years back. It basically allowed graduates from UK institutions to work in the UK for 2 years. So there is no provision in the changes that have been published so far for what is going to be called the graduate route. And is coming into place in in the summer of next year. So from the summer of next year, there's going to be a route called the graduate route. It's similar to what the post-study route was. It will be available to those graduating after it comes into force sometime in the summer, we're not sure when. And it would allow graduates to live and work in the UK and look for work in the UK for up to 2 years after graduating. Now, one thing to consider is that the route will not necessarily lead to settlement. We don't have the rules on this route, so we don't have the details on this route. But although it's a welcome change because it gives graduates an option, again, if you can switch into a route that is on the path to settlement, then that is more beneficial to the applicant. With the post-study work route, the previous route, there were situations where a student would work for an employer on that route, kind of always thinking they would be sponsored by the time they got to the end of the 2 years, but then they never were. So if you're able to get sponsorship, then that's better. And again, for employers in terms of all of the benefits to productivity and employee well-being that go along with the security of knowing, you have long-term options. I would offer sponsorship over relying on the new graduate route for work rights, if possible. Talita, do you want to answer Mehdi's question?
Okay, yeah. She's asked any changes to entrepreneur visa. Well, that changed, God, how long has it been now? Over a year, hasn't it? Yeah, so that's been replaced by the new innovator and startup visa. So quite a lot of changes for that route. And if you do have a specific inquiry in relation to that, then I would suggest that you contact us so we can go through that with you in much more detail.
Yeah, so the Tier 1 entrepreneur route changed to the innovator route in March of 2019. Other visa routes for entrepreneurs include the global talent route, depending on your sector. There is one small change to the global talent route, basically to allow employees in a product-led digital tech company to be eligible, even if they're not within the C-suite of roles at that company. But otherwise, as we mentioned, most other routes are staying the same with very minor changes. Then Husna asks, thank you for your question, Mehdi, and hi. Husna asks, how many years can the skilled worker route visa be issued for? So I haven't reviewed that in detail. So I would, off the cuff, I would say that there's no change there. And so it would be a maximum of 6 years for regular applicants, or 9 years for those considered high earners under the skilled worker route, if it's equivalent, if this point stays from the Tier 2 general route, are those earning 159,600 or more. Talita, have you noticed a change there? I think that might be the same.
Yeah, there was nothing in this statement of changes, so I think we'd have to wait for further guidance from the Home Office on this. But usually it's up to the sponsor really, and most sponsors go for each sponsor up to 3 years or up to 5. Because they've not said anything about this yet, we'd assume it's going to stay the same, just like what you've mentioned. But I think we wait for further guidance on that.
Yeah, sorry, I think that there are two questions here that we're each answering a different one. So there was a question about, that I might have skipped actually. No, you were saying there was one about 3 years. So basically for the skilled worker visa, you can assign a certificate of sponsorship for up to 3 years or 5 years still, and sponsor someone in that way. And then Husna was asking, what's the max amount of time to spend on that route? So I think it's 6 years for most, or 9 years if you're a high earner.
Yeah.
Then we've got, would sponsor duties remain the same? For example, informing the Home Office when a worker leaves, changes in salary, etc. I think most sponsor duties will remain the same. So these sponsor duties are actually only in sponsor guidance. They're not in the rules, and we don't have details on them. So I imagine there will be a fair few changes, but I would assume that generally most of the sponsor duties remain the same, which is significant because, you know, at the beginning of the UK's Brexit journey, there was a lot of talk about major modifications to the structure of the sponsorship regime. And I think it's clear now that that's not happening. You know, so some of the proposals were for some industries to have umbrella sponsorship organizations, such that small businesses within that sector could have a very light touch relationship with sponsorship, where actually that umbrella organization acts as the sponsor and assigns the certificates of sponsorship. So it seems like all of that is out the window, and really I expect that most sponsor duties will remain the same. So that includes record keeping duties, reporting duties, for example, reporting on changes in migrant circumstances, et cetera, that Husna mentions, and compliance duties. So ensuring that certificates of sponsorship are only assigned under the correct circumstances. Sanjay asks, for global talent visa holders getting indefinite leave to remain, are there specific criteria to be fulfilled? Why, yes, there are, Sanjay, and I would encourage you to get in touch if you need advice on those. I won't go into it now. It's just a bit off piece for the subject of this webinar. Thank you so much for all your very kind comments in the chat and your thank yous. You know, it's really our pleasure. We love this stuff, so it's fun for us. And I'm really glad it was useful for you guys. Thank you so much for asking all the questions. That's great. Do get in touch with us. I'll just show you our email addresses again here. If you want to email us to follow up on any questions we didn't answer here, or if you have questions in future, please don't hesitate to get in touch. So I think if there are no more questions, then we reached the end of this session, and it leaves, again, you're all most welcome. I'm only left to say thank you very much for joining us. Do sign up for our newsletter so you get invitations to future webinars if you haven't done so already. And I'll let Talita say bye as well.
Yeah, thank you, and thank you for your kind words. Thanks.
Bye, everybody.